This is question 1, February 2024 California Bar Exam. I always start with the calls of the question because I need to figure out the subject as rapidly as possible so that I have the structure of the law of that subject in my mind when I'm reading the facts and spotting the issues. So at the bottom of the page here, I see answer according to California law. That narrows the field down for me considerably. And I see 4 calls. What are Henry's and Wendy's respective rights and liabilities, if any, regarding? Okay, California Bar, they give you a huge hint. An H name and a W name, that's husband and wife. This is probably California community property. If it's wills or trusts, often it's a T name, Tess or Tom for testator. First item in the list is the house. So a piece of real property, yeah, this is California community property. Second call, the bank loan. Third call, the auto repair garage. And the fourth call, Wendy's investments. I'm virtually sure it's California community property. And for each of these items, I'm going to need to discuss the original source of the property or the loan, and then discuss any transformation that's happened that might affect the source of the property or the loan, and come to a conclusion about who has rights or is liable for that property or loan. Okay, so let's see what they've given us. Henry and Wendy married in California in 2012, so they're telling you quasi-community property is not an issue. Henry got a job as an auto mechanic. Wendy's aunt, who owned a house free and clear of any mortgage, gave it to Wendy. So this is a gift. That invokes the general rule about separate property. And you know, in any community property essay in California, you're going to need those general rules about community property and separate property. So the presumption is that something acquired during the course of the marriage through the skill and effort of the spouses is community property, and that property acquired before marriage or after permanent legal separation or by gift or inheritance, and all the profits from those sources is going to be separate property. So my first issue about that house, which is call 1, is to define it as separate property when she acquired it. But then they go on to say Wendy then added Henry on the title document to the house. That is a transmutation. And so I need all the rules for transmutations. Has to be in writing. This is. What do I know about transmutation? Well, let's go over to proponics and look at the rules I would have memorized before the bar exam. So in the way we organize the law, under California community property, this would be conduct by the parties that changes the character of property. So let's see what we have there. We have separation, transmutation, contributions and improvements in Pereira Van Camp. This is a transmutation. It's not premarital, it's marital. And spouses may transmute property to each other without consideration, but the agreement must be in writing by express declaration, and then there are a bunch of exceptions which don't apply here. So that's a good issue on the house. She has transmuted it to community property, which means that they both have rights in that house. Wendy and Henry lived in the house. Wendy then began singing with a local band. Some years later, Wendy and the band began traveling and performing across the state. The band was profitable, and Wendy sent money home to Henry and stayed with him periodically. Okay, why are they giving me those facts? I know on a California essay, all the facts go to issues. And what this reminds me of is the requirements for a permanent legal separation. So back over to proponics to see what rules I would have in mind on the bar about legal permanent separation. So that's the first topic under conduct by the parties. We see separation. All earnings after permanent separation are separate property. But what I want to know is, what do you need to perfect a permanent separation? You need physical separation, no intent to return, to reconcile, and you need to communicate that intent to the other spouse. And there's some more detail within our organization of the law. A reminder that physical separation means they have to live apart. You can't any longer just put a tape down the middle of the house and say, this side is his, this side is hers. That doesn't work anymore. And it takes very little to find the intent to reconcile. Going to therapy together is a way to do that. And I don't see that here. I see a physical separation, yes. However, Wendy is sending money home to Henry, and she stays with him periodically. So there is not a permanent legal separation at this point in the facts. And I would want to write that as an issue. The next paragraph tells me that Henry decided to purchase an auto repair garage and applied for a loan from a bank for that purpose. Okay, that's his line of work. It told me up above that he got a job as a car mechanic. So this is his line of work for the benefit of the community. So there's nothing wild going on here yet. But then, because Wendy was on the road with her band, Henry forged Wendy's signature on the loan documents without her knowledge. That is fraud. It's a breach of the fiduciary duty one spouse owes another. The bank approved the loan using the house as collateral. Well, if he forged her signature on the loan document, then the intent of the bank was to loan the money to the community, and they would be entitled to go after the community for those loan payments. I need to write about the intent of the lender. I need to talk about who's liable for that loan. What can the bank go after? I need to fit everything I know about that into my answer. He purchased the auto repair garage with the loan funds. Title to the auto repair garage was taken in Henry's and Wendy's names in joint tenancy. And yet, apparently, she has no knowledge of this property. By title, it's community property. But form of title is not conclusive. Interest is the key. Here, it was purchased with community funds, and the collateral used was community property. It's a community asset. So she has a 50% interest in that repair garage. But he has committed fraud. So we will see what happens in the next paragraph. But those are the issues, the main issues I see in these facts. The bank loan, who has rights and liabilities? Well, as it stands now, they would both be liable. After a while, Wendy told Henry that the marriage was over. She stopped returning home and also stopped sending money to Henry. She has now perfected a permanent legal separation. That's the big issue I need to write about that. She began making independent investments with her earnings. So what's the legal consequence of perfecting a legal permanent separation? Well, after that, her earnings are her earnings. His earnings are his earnings. So they are separate property at that point going forward. Henry was unable to make the loan payments, and the bank demanded payment of the loan in full. Shortly thereafter, Wendy filed for dissolution of marriage. Okay, so her investments are separate property. What do we have in the calls? Call 1, the house. All right, we said it started as separate property, but then it was transmuted into community property. Those are the issues I need to write about the house. The bank loan. The intent of the lender was to loan to the community. And so the lender would be able to go after payments, the loan payment in full from the community funds and from each of the two spouses separately if need be. But Wendy has rights about that loan. So ordinarily, that loan would be a community loan. But he committed fraud, and in the interests of justice, the court may award the entire loan debt, that entire liability, to him. When there's been a breach of fiduciary duty by one spouse, the court may deviate from the presumptive 50-50 split at dissolution, and this is a pretty clear case of an example of when they would do that. So when you're thinking about breaches of fiduciary duty, don't just think about the court deviating in terms of distributing the assets. Also think about the debts. One way for them to fashion relief would be to assign the entire debt to him. Those are the issues I see about the loan. The auto repair garage. She's a 50% owner in that auto repair garage because it was acquired during marriage, and also because title was taken in both of their names as joint tenants. The investments are pretty straightforward. They were after legal permanent separation. They're Wendy's separate property. As always on the California bar, that's a lot of issues to write up. And I think the trickiest issue here was trying to fashion relief by the court for the fiduciary breach of trust that the husband perpetrated here.